force of habit.
Well, Lydia, I was about to deal with section 75A. I'd taken you to the three requirements that have to be satisfied under subsection 1 for the section to apply. And I think the easiest way of testing this, and indeed of testing the difference of views between the parties on this, is just to look at the transactions we're concerned with on the basis of either either PBL being P or MAR being P for the purposes of subsection 1. I said before the short adjournment that we adopted the reasoning in the first tier tribunal and the upper tribunal. Just for the record, in the first tier tribunal, it's paragraphs 235 to 253 at MS 382 to 386. And in particular, Judge Nolan in the upper tribunal at paragraphs 137 to 145, MS 331 to 333, which essentially accepted, I think, the submissions that the Revenue had made as to how one determined whether the section applied, and that PBL was correctly identified as P. We say that it is PBL and nobody else. It's not that we're seeking to sort of make choices between different people. We've always contended that PBL is the correct P in the context of these provisions. But the respondent and indeed the Court of Appeal adopted an approach which was more a sort of sequential approach for testing the section's application by saying, well, you've got these series of transactions, let's stop at each stage and see whether or not section 75A applies at each stage. And when you do that, we say that you arrive at the same conclusion, that it's PBL that is P for these purposes. And if we just test that by reference to the transactions that we have, so looking at subsection 1 of section 75A, we're looking at one person V, that's the Ministry of Defence, disposes of a chargeable interest, and another person P acquires it or a chargeable interest directly deriving from it. Now, at the first step, the contract between the Ministry of Defence and PBL, that does not fit within the terms of the section because, as we know, that's not a land transaction and will ultimately be disregarded. So I think we can move quickly on to the position that the Court of Appeal took, that actually when you get to MAR, you find that MAR can be P, and that therefore that is the way in which the section applies, if it applies at all. This, of course, was obiter by the Court of Appeal because they'd already decided that section 71A operated not to exempt MAR, but on the basis that they were wrong about that, they concluded that MAR would be P for the purposes of subsection 1A of section 75A. If one considers only the transactions up to MAR's acquisition of the freehold, that's the contract to PBL, the subsale to MAR, and then the simultaneous completion of those two contracts with the conveyance ultimately to MAR, then looking at subsection 1 of 75A, the MOD has disposed of a chargeable interest and another person, MAR, has acquired it. So you then notionally tick the box on that. A number of transactions, including the disposal and acquisition, are involved in connection with that disposal and acquisition. That is true. We've got the scheme transactions identified. And then we're asked under C, the sum of the amounts of stamp duty land tax paid in respect of the scheme transactions is less than the amount that would be payable on a notional land transaction affecting the acquisition of V's chargeable interest by P on its disposal by V. Well, we know that no stamp duty land tax is actually paid in relation to the scheme overall, but of course if you stopped the transaction at MAR, as I illustrated earlier this morning, MAR would, by reference to that transaction, be subject to stamp duty land tax on 1.25 billion under the completion of the secondary contract under section 45(3), and would be liable to stamp duty land tax on that basis. And that would mean that paragraph C is not satisfied, because that's the amount that should have been paid by MAR at that particular point. So it wouldn't be that the scheme transactions, those being defined up to that point in time, is less than the amount that would be payable on a notional land transaction between MOD and MAR, because it would be exactly the same amount. It would be the same consideration for the notional transaction and for the actual transaction, so there you wouldn't tick the box of C.
Well, that's right, but how does it help you identify P? You can't reason backwards, can you? Or can you? From the fact that you wouldn't then have a shortfall to the identity of P.
Well, I agree, my Lord, and that's why we say that the approach adopted by the first-tier tribunal and the upper tribunal, Judge Nolan, in identifying P is the correct one. But what I'm saying is that even if you test it by the argument the respondents made and that the Court of Appeal accepted, it's difficult. You don't arrive at any different conclusion. And my Lord, I accept your point that it's your sort of reasoning back in a way that is not appropriate. But the argument there would be that the later transactions, in other words, the transactions that follow on after MAR's acquisition at this point, are not schemes transactions because they're not involved in connection with the disposal and acquisition of the freehold between the MOD and MAR, stopping the transaction at that point. Of course, it's perfectly true, and I accept that, as we saw, subsection 2D allows a transaction to take place after the acquisition by P of the chargeable interest. So theoretically, or at least one could argue, that actually you do have to take account of the lease to PBL after the acquisition by MAR of its freehold at this point, because it's a later transaction which can be taken into account. Of course, the effect of doing so is that triggers the conditions of section 71A, so that although on the scheme transaction you've identified, being the acquisition by MAR of the freehold interest from the MOD, it would ordinarily have paid stamp duty on 1.25 billion. If you take account of the later transactions, you find that it can claim exemption under section 71A, and you're told under subsection 7A of 75A, if you look down to that, I'm on MS 1079, this section does not apply where subsection C is satisfied only by reason of section 71A to 73. So MAR would not again tick the box on C, because although under the transaction you're looking at, the acquisition of the freehold by MAR, it would normally pay stamp duty on 1.25, stamp duty land tax on 1.25 billion. The reason why it doesn't pay stamp duty land tax on 1.25 billion is because it can claim exemption under section 71A, and therefore on even looking at later transactions, you conclude, using this line of reasoning, that MAR is not P. If you then move on and you look at PBL itself as P and do the same test, you can see that the acquisition there is by PBL of a chargeable interest derived from the MOD's freehold. There's a number of transactions involved that are included as scheme transactions that lead up to PBL's, the grant of the PBL lease. And then the question is whether the sum of the amounts of stamp duty, land tax, paid in respect of the scheme is less than the amount that would be payable on the notional land transaction. Looking at PBL's position, the notional land transaction would, of course, be its acquisition of the freehold, or be deemed to be its acquisition of the freehold from the MOD. It would pay stamp duty land tax on that. There's no other stamp duty land tax that's paid in the transaction. But in this case, the reason why PBL doesn't pay stamp duty land tax is twofold. Firstly, of course, its lease may qualify for exemption under Section 71A, but the other cause of it not paying any stamp duty land tax is the relief that it gets under Section 45(3), because the conveyance to it of the land is ignored under the subsale provisions. So the reason why the PBL satisfies paragraph C, whereas MAR doesn't, is because MAR is always relieved entirely under Section 71A, whereas PBL has to rely on the combination of both subsale relief and Section 71A to remove or ensure that it's paying less stamp duty land tax than would otherwise be the case.
It's the word only in subsection 7 that you're finding.
Indeed.
Yes.
And the fact that it has to rely on the combination of reliefs to ensure it doesn't pay any stamp duty land tax. And that was essentially the reasoning that was accepted again by the tribunals in this particular case, and we say that PBL is P in any event on their analysis, but even if you analyse it in a different way, as I've just done, you still reach the conclusion that it's PBL that is the person who ticks all the boxes under Section 75A. That being the case, under Section 75A, you're told that in subsection 4 of the section, that where the section applies, as we say it does to PBL, any of the scheme transactions which is a land transaction shall be disregarded for the purpose of this part, but there shall be a notional land transaction for the purposes of this part affecting the acquisition of V's chargeable interest by P on its disposal by V. So for these purposes, PBL is treated as acquiring the freehold interest in Chelsea Barracks. And then subsection 5 tells us, and this is really moving on, subject to one point I'll just come back to the consideration issue. Subsection 75A sets its own terms for the consideration that's chargeable. The chargeable consideration on the notional transaction mentioned in subsections 1C and 4B is the largest amount or aggregate amount given by or on behalf of any one person by way of consideration for the scheme transactions, or received by or on behalf of V, or a person connected with V by way of consideration for the scheme transactions. So, as it turns out, in the way in which Parliament has chosen to specify the consideration for the scheme transactions as it applies in this case, the Ministry of Defence, of course, received, I think it was 937 million or thereabouts, anyway, slightly less than a billion. My mind's got a blank as to exactly what the figure was. Whereas the largest amount paid by any person by way of consideration for the scheme transactions was, of course, MAR, who paid 1.25 billion for under the subsale arrangement. Now, in relation to that, again, the first-tier tribunal and Judge Nolan in the upper tribunal agreed that that was the only conclusion one could reach in respect of these provisions, even if it did not look entirely right, but that may be just a result of the blunderbuss approach rather than the sniper's bullet approach that the first-tier tribunal referred to. Justice Morgan in the upper tribunal, and none of these things were considered by the Court of Appeal, Justice Morgan in the upper tribunal concluded that Section 75B enabled him to reduce the consideration effectively to the amount that was received by the Ministry of Defence, and by his casting vote, he therefore decided in the upper tribunal that that was how Section 75B operated. We say, though, that that plainly is not correct for the reasons that were given by Judge Nolan in his decision in the upper tribunal. Justice Morgan's, for your record, was at the upper tribunal paragraphs 79 to 90, where he analysed it, MS 313 to 318, and in Judge Nolan's analysis was in the upper tribunal paragraphs 152 to 170, MS 336 to 341. If we look at Section 75B, we see that it tells us that in calculating chargeable consideration on the notional transaction for the purposes of Section 75A5, consideration for a transaction shall be ignored if or insofar as the transaction is merely incidental to the transfer of the chargeable interest from V to P. And one of Justice Morgan's conclusions for saying that he could exclude part of the consideration apparently set by Section 75A5 was the expression if or insofar as, where he said that implied that you could effectively disaggregate the sum to work out what each bit was being paid for, and the bit over the amount that had been paid to the Ministry of Defence was attributable to other matters such as development costs, interest, stamp duty, land tax, and the like. But what you're told, and this is effectively Judge Nolan's conclusion, is in subsection 2, you're told a transaction is not incidental to the transfer of a chargeable interest from V to P. And then you're told, A, if or insofar as it forms part of a process or series of transactions by which the transfer is affected, and obviously all of the transactions that we're looking at are transactions which form part of the process or series by which the freehold or interest is passed from the Ministry of Defence to PBL. And then additionally in 2C we're told if it's of a kind specified in section 75A3, which is specifically a subsale to a third person. So we say this is whatever else subsection 1 means, and Judge Nolan talks in terms about the difficulties, and also Justice Morgan talks in terms of the difficulties of interpreting subsection 1, but Judge Nolan says, well, it doesn't really matter how you conclude on 1, because it's apparent from 2 that you can't treat the subsale to MAR and MAR, part of MAR's consideration as knocked out, because you are told, A, that you know it's a subsale anyway, but also you know it's part of the process by which the interest is passed from the Ministry of Defence to PBL. Subsection 3 also talks about a transaction may be incidental if or insofar as, again those words, it undertakes only for the purpose of relating to, and then you can see construction of a building, sale of supply of anything other than land, a loan secured by a mortgage or any other provision of finance to enable P to pay for part of a process or series of transactions by which the chargeable interest transfers from V to P. So you would think, or you might think at first reading, that that enables part of the consideration to be taken out, the financing part that MAR had paid. But subsection 4 then tells you that paragraph C of subsection 3, in other words, the reference to finance, is subject to subsections 2A or C. So even if you could have relied on subsection 3C, you're told by subsection 4C that you can't, where those are either subsale or transactions which are part of the process or series for transferring the interest in question. So we say, for the reasons that were given by Judge Nolan, the consideration is not reduced by section 75B and remains 1.25 billion. One other point I should make in relation to the section 75A issue is just the point that the revenue makes, but which was rejected by the Court of Appeal, that subsection 75A1C talks in terms of the stamp duty land tax payable. And one reason for concluding, of course, that section 75A was not in point and that MAR should have paid the tax was that the Court of Appeal concluded that section 71A did not exempt the transfer to MAR. But of course, MAR and PBL still filed their self-assessment returns on the basis that they were entitled to that exemption, and therefore no stamp duty land tax was ever actually assessed or became payable, and the revenue therefore say that actually it is section 75A remains available to it in the circumstances of this case where the parties have actually claimed exemption under section 71A and been allowed exemption under section 71A, because you still satisfy the terms of 75A subsection 1, in particular paragraph C, because that talks about the sum of the amounts of stamp duty land tax payable in respect of the scheme transactions, and no amount of stamp duty land tax ever became payable in respect of those transactions. It is actually, we deal with this point in one of the appendices to our, I think it's in one of our appendices, it may be in the main body of our written case. We deal with it in our written case, but it's actually quite a simple and short point, and it actually goes back to a case in the House of Lords, or the point is made in the House of Lords. It's not actually in the authorities because we've got a more recent authority we can put in, a case called Whitney versus the IRC, where Lord Dunedin set out the basic framework for charging taxes. And as he said, the basic position is that the statute establishes liability in the sense that it charges something to tax. But then he said that liability, as established by the Act, in the sense of whether or not tax is charged, does not depend on assessment. But, he said, assessment particularizes the exact sum which a person is liable to pay. And we say without assessment, nothing is payable. And, of course, nothing has been assessed, given the claims that were made by the parties here to be allowed the exemption under section 71A. The point, or a similar point or issues were discussed by this court in a case called Cotter, which I think Lord Hodge particularly will be familiar with, as I think he gave the only judgment in that case. Cotter is at Authorities Bundle 3, tab 42, and it's MS 1628. And I don't think it was obviously a case that was based around income tax assessment provisions, but the assessment provisions, we say, are basically the same approach adopted in relation to stamp duty land tax. Given the time, I will not take you through in detail, but the relevant paragraphs, I think, which deal with the essential points are paragraphs 24 through to 28. And again, I've marked paragraph 31 and 35. It was, of course, a case where the taxpayer had submitted a tax return but had left it to the revenue to do the calculation of the tax that should be assessed. And then he made a claim in relation to a later year as to which he wanted to carry back and reduce the tax he had to pay in the year for which he'd made a return. And the question was whether or not the revenue had to give effect to that claim effectively through the return, or whether they could open a separate inquiry into the claim but still demand the tax that they had assessed in respect of the earlier year. And this court concluded that the revenue in the circumstances were entitled to recover the tax in respect of the earlier year, and even though there was an inquiry in relation to a claim for a later year. The principles, though, that are discussed, I think, affirmed a basic point in Whitney that actually the assessment is what quantifies the amount of tax that becomes payable, and therefore when section 75A 1C talks in terms of tax becoming payable, no tax did become payable, and therefore we say section 75A is still open to the revenue in this case, whether or not you conclude that the exemption under section 71A was available to MAR or otherwise.
I wonder, Mr. Gammy, it might be useful to have the Whitney case available to us, because the distinction between tax chargeable and tax payable in the context of income tax under the TMA had expressed statutory provision, as I recall, in section 81AA.
Yes.
Yes, where chargeable was the amount taking account of reliefs and allowances, and payable was the difference between the chargeable amount and any income tax already deducted at source, I think.
Yes, under PAYE.
Under PAYE. So there was there a specific definition. I think, so the analogy isn't perfect, but you are saying that Whitney is a generalized statement of the way that taxation liability and then payability is established.
Indeed. It is merely a paragraph in Lord Dunedin's speech, yes. Which has been frequently referred to in the other cases as being embodying the sort of basis, the relationship,
basic structure.
The relationship between charge, assessment and collection.
And is it the HMRC's position that whenever payable is used within the 2003 Act, it is talking about payable after assessment?
Indeed, my Lord. I mean, there was certainly in the context of 75A, where it's comparing the two, the amount that's actually payable under the scheme transactions and the amount that would be payable under a notional transaction, we say it would be referring to an amount that is actually assessed.
The circumstances that would arise were there an assessment?
Yes.
I see. Okay.
Well, Mr. Gammy, you've reached the end of your time. Have you reached the end of your tether?
Madam, I think I have, yes. I mean, certainly in relation to the latter points, the Section 75A issue and the consideration issue, they're issues in which the revenue was essentially successful before the tribunals. I mean, other, of course, than Mr. Justice Morgan's consideration of Section 75B. As I said at the beginning, there are one or two peripheral issues that arise, but I'm happy to leave those to my reply to the extent that my learned friend wants to raise them.
Yes, well, you've given yourself plenty of time in reply, so
yes.
You should be able to pick up any loose ends.
But I will also
Ms.
have
McCarthy
to
is
leave time
going
for
to-
my learned friend to deal with the human rights issues.
I understand that.
as they are dealt with. Yes.
Thank you very much indeed. Thank you.
Thank you, madam.
And Ms. McCarthy, I imagine you want to keep your powder dry until reply.
Yes, thank you, my lady.
My lady.
Yes, Mr. Thomas.
I need only briefly travel over the ground that my learned friend has already travelled over this morning in relation to the statutory provisions, but there is a certain degree of disagreement between us as to exactly how those provisions operate and should be construed. If I could start at page 1058 in the bundle. With section 42, the purpose of the tax is to charge land transactions rather than documents. And as your ladyship saw this morning, land transactions are defined by section 43(1) as the acquisition of a chargeable interest. And that definition is central to everything else that follows in the legislation. Section 43 defines acquisition fairly widely. It also defines, and we say it defines for the purposes of the Act, the concepts of purchaser and vendor in 43(4). And those are the parties to the disposal and acquisition of the subject matter of the land transaction. And the subject matter of the land transaction is itself defined in section 43(6) as being the chargeable interest, together with appurtenant interests and rights that might be attached thereto. So the structure of the Act is entirely to focus on there being a land transaction, and that requires the movement of a chargeable interest from vendor to purchaser. It defines vendor and purchaser by reference to that movement and that chargeable interest. And if there is no land transaction, there is no charge to tax. The Act does not charge transfers of major interests in land. It does not exempt the transfer of major interests in land. It taxes and exempts land transactions. And section 48, which is at page 1063, defines the chargeable interest. And at the time with which we were concerned, that definition had to cover property interests not only in England and Wales, but also in Scotland. And although it, as you see, defines chargeable interest fairly widely, it then takes out exempt interests, which are defined by section 48(2), where the only relevant category is a security interest, which is defined by 48(3) as an interest or right held for the purpose of securing the payment of money or the performance of any other obligation. And winding up this rapid trawl through the initial sections, one reaches section 49. And that defines a chargeable transaction as a land transaction which is not a transaction that is exempt from charge. So in deciding whether or not a land transaction is a chargeable transaction, it has to be that very transaction which is exempt from charge, not some other transaction, not the transfer of a major interest. It is the land transaction which is a chargeable interest, unless it, the land transaction, is a transaction which is exempt from charge. And of course, the importance of that is that chargeable transaction is then picked up in Section 55 of the Act, and it's Section 55 which imposes the tax charge by reference to the chargeable consideration for the chargeable transaction. And those are statutory concepts, constructs, for the purposes of this particular SDLT code. And in my respectful submission, when one is meeting those concepts within the code, unless one is directly told otherwise, one ought to expect that when the draftsman uses the words, whether they be chargeable interest, land transaction, purchaser or vendor, they mean what he has defined them as meaning at the beginning of the Act. The draftsman has the full richness of the English language to play with if he wishes to engage with a similar concept, not in the context, for example, of a land transaction, but in the context of the transfer of a major interest in land. One would not expect, if one was dealing with a transfer of a major interest in land, that the test would then be, as to whether or not that transfer was exempt, that the vendor was to be defined otherwise than in accordance with 43.4 and, when it later came into existence, 45.5a. And suggestions to the contrary made by my learned friend should, I would respectfully submit, be treated with a considerable degree of scepticism. Now, there can be no doubt here that PBL bought Chelsea Barracks from the MOD, and had it bought that, entered into that contract and then completed the transaction with the assistance of a loan from an English bank in the ordinary conventional Western finance, that PBL would then have acquired the chargeable interest. And all that the relevant bank, say HSBC, might have obtained would then have been a security interest within Section 48. And if that had been the case, then that interest would not have been a chargeable interest for the purposes of the legislation. It would have been outside the scope of SDLT because it would have been an exempt interest under 48.2. But PBL was a creature of the Qatari Sovereign Wealth Fund, which owned an 80% holding in the company indirectly. And it decided that it should acquire that property interest in a Sharia-compliant way. And the effect of that, we say, was that the usual exemption for security interests did not protect MAR, the financial institution, because the essence of the Ijara model of Sharia finance is that the financial institution has to acquire the property interest itself. And it then exploits that property interest by letting the property back to the counterparty until such time as the counterparty can afford to buy the freehold interest or the long leasehold or whatever it might be from the bank. And in such cases, the effect of the legislation is to impose the charge on the bank because it is the bank which acquires the chargeable interest disposed of by the vendor. And there are only two exceptions to that. One is where it is a refinancing transaction, where there has been some other Sharia finance put in place earlier. And the other is where the property interest is acquired not from a third party, but is acquired from the counterparty, the person, as they're called in 71A themselves. If I could ask you to go to page 242 of the bundle. What we have done at that stage, it's behind our case in core bundle 1 tab F as well.
Sorry, could you give me the MS number again?
Yes, the MS number is 242.
242. Thank you.
Yeah. And what we've done in that particular section is to set out a number of different iterations of the most important provisions of the Act with which we are concerned, and highlighted the amendments which were made to those sections at different times by different finance acts. And what one sees at page 242 is in fact section 72, which was the first iteration. And that came into effect immediately on the operation, on the implementation of SDLT on the 1st of December 2003. And at that time, it extended not only to England and Wales, but also to Scotland, until it was decided that the legislation didn't work terribly well for all jurisdictions, and it was then broken down into separate jurisdictions from Scotland, from jurisdictions in England and Wales. And at this stage, back in 2003, it only applied to individuals, and subsequently it was extended, as one sees, to other institutions, organisations as well. And subject to that, right from the start, the legislation was carefully crafted because Section 72.2 only provided for an exemption for the first transaction in the event that the vendor was the individual, or, as I say, another financial institution which had already entered into Sharia transactions. All other transactions involving an acquisition of the property by the financial institution would always be chargeable to tax. And it's a characteristic both of the decision of the First Tier Tribunal and of Judge Nolan in the Upper Tribunal, and possibly of Mr. Justice Morgan as well, that the tribunals failed to appreciate that the normal course of events would be that the financial institution was indeed going to be liable for tax. It was only in those exceptional cases that the financial institution would be exempted from tax. By contrast, going to 72.3, the second transaction was always going to be exempt from tax, subject only to compliance by the financial institution with its own SDLT obligations. And one sees immediately that one of the things that could have been expected of the financial institution if it didn't fall within section 72.2, as it then was that it would have had to pay tax. So distinctions which were drawn by the lower courts between financiers on the one side and purchasers on the other were entirely misconceived. And from the outset, one therefore sees that the legislature deliberately avoided imposing the tax charge on the individual, in contrast to what the position would have been had mortgage finance been used, where it would have been the individual who would have had the liability for the tax and the financial institution which would have been exempt. So if one goes on to 1059, manuscript 1059, when the financial institution acquires the property, it does so in circumstances where section 44 is engaged. SDLT will become chargeable because the financial institution will be a purchaser which has acquired a chargeable interest, and the occasion on which the charge will be imposed will be on the completion of the contract, and that's 44.3. My lady was looking, I think, at 44.8 earlier, but that's the one which applies where there's both substantial performance
No, I found that, yes.
Yes. So that's how the legislation would have worked had, in fact, MAR bought Chelsea Barracks directly from the Ministry of Defence. And rhetorically, one asks, can it be that MAR avoided that tax because the property passed from the MOD, pausing only for a scintilla temporis with PBL before it moved on to MAR? Was it the statutory purpose of 71A2 to give exemption in those sorts of circumstances? And the reason my submission why the answer is and should be no is that because the way in which the SDLT code works is to adopt the policy of disregarding evanescent acquisitions of that kind. And that it was that was achieved by the tailpiece to section 45.3. So if you have a chain of land transactions, one disregards the prior transactions for SDLT purposes, provided they have the necessary ephemeral quality. As long as they're acquired and disposed of in the same breath, at the same time as, and in conjunction with the substantial performance or completion of the final contract, they themselves are disregarded. And the reason they're disregarded is because they have no reality. In this case, the commissioners eventually admitted that the characteristics existed in this particular case, and therefore PBL was not liable for tax on its acquisition from the MOD because it had in fact participated in a sub-sale transaction which passed the property directly through to MAR. And in all those sorts of cases, the idea is that the person at the end of the chain should be the person who has the tax liability, and it's then computed in accordance with the rules in 45.3. Because it is they and they alone who may reasonably be said to have acquired the chargeable interest. So section 44 is dealing with a normal conveyancing transaction where one has a contract for a land transaction under which the transaction is to be completed by a conveyance. It's concerned to secure a charge to tax, but it's concerned also not to impose that charge to tax before the time when the purchaser has obtained in substance everything that he wants to get under the terms of the contract. And that's why substantial performance came in, because it was all too easy in stamp duty days to avoid the imposition of the charge to tax by resting in contract or undertaking all those other devious transactions that used to take effect, which left the purchaser with the effective benefit of the land but without legal title. So 44.2, as we've said, disregards the contract as a land transaction. And then you've got 44.4, which deals with substantial performance, 44.3, which deals with completion, and 44.8, which deals with cases where both are involved. What 44 did not do was to make provision for chains of transactions, and those are left to section 45, which is at page 1061, effectively. And 45.1b talks about an assignment, sub-sale, or other transaction as a result of which a person other than the original purchaser becomes entitled to be called for a conveyance. Again, 45.2, the transfer of rights itself is not treated as a land transaction, it's disregarded again. And 45.3 then creates a secondary contract. And it's to be observed that that secondary contract doesn't always mean that there is no charge to tax on the intermediate, the original contract, or the completion of the original contract. It depends whether or not they take place within the very limited sphere of the tailpiece to 45.3. Otherwise, you get two charges to tax.
What do you mean if they're not connected sufficiently by time?
Well, it's never been entirely clear what is meant by those words or what the revenue are willing to give them a meaning that is compliant as far as most developers or land parties are concerned. But it does talk about not only at the same time as, but also in connection with. Mm-hmm. So one could say that it's very tightly drawn indeed. But generally speaking, there hasn't been a great deal of difficulty between the revenue and taxpayers as to when those sections are engaged, as long as you can prove that they were simultaneous, or if not simultaneously, they took place one immediately after the other, or within a certain period within the same day. That will do for the purposes of the legislation.
Can I just ask about your overarching, as it were, policy picture that you give us, which I think depends in part on the proposition that ephemeral transactions have no reality and are for that reason taken out of the text. Is that right?
Yes.
Well, in the ordinary Section 45 situation, ordinary subsale, leave aside all Islamic financing. Perfectly ordinary subsale. Developer buys a large area of land, divides it into plots, sells off in anticipation of taking his own conveyance, and indeed before substantial performance, sells off the various plots. Is it realistic to say that his contract with the vendor has no reality?
No,
or is it simply that there is no desire to impose successive dollops of tax?
Well, in those sorts of cases, it is sometimes very difficult for developers, in fact, to get themselves into that sort of position, because the difficulty that the developer will generally have in selling off plan, in the sort of case you're dealing with, is that they will have taken possession and therefore substantially performed.
I understand that.
It's only in a very special case where, in fact, the developer keeps off the site and is able to, say, lot up into a number of different lots, not take a conveyance, and then eventually to ensure that both contracts complete at the same time as in connection.
It has no reality. The only reason he'll be doing it is because he's intending to make a substantial profit out of it.
But in a different context, generally. He'll generally take his profit in those circumstances, partly, admittedly, on the on-sale, but also partly on the building contract he enters into with the sub-purchaser.
All right. Okay. Well, but you do say that has no reality.
But that the interest of the developer will have no reality if he's going to bring himself within the scope of the tailpiece. Not for the purposes of the code, anyway.
Right.
The more typical kind of, I don't say more typical, but I mean the subsale which springs to mind in this context might be the hot market situation where a property is simply traded from A to B and B to C and C to D in a strongly rising market, in each case with a markup.
Absolutely.
And eventually it's just conveyed from A to D unless the A-B conveyance prohibits that, in which case it just all on the same day, as in this case, goes around the houses.
Or quite often one was unwilling to tell one's vendor that one had, in fact, a purchaser lined up because the vendor might otherwise not be willing to engage further or
you might put
block.
Yes. Yes.
There's nothing unreal about that.
No, but
the point is that for policy reasons, the tax statute doesn't want to impose successive charges to tax, which dates, I understand, from long before this act.
Well, in my submission, there is an unreality, because the unreality is to the title interest. The unreality is not to the contract, because it's the contract which is disregarded.
Yes, true.
And it's the contract out of which you make your money.
Right. Mm-hmm.
But it's not just the contract that's disregarded, it's the completion is not treated as a land transaction.
I apologise. The contract is disregarded under 44.2, and therefore it's open to a person who has entered into a contract to deal with the property interest at that stage. But the reason you're making your money is because you accept that you can negotiate with your contract rights without actually having either taken possession of the land or taken title.
I mean, the reason may just be historical, in the sense that they're building a new tax to get what they got under the old tax minus all the ways round it. And because you never got money under the old tax until there was a conveyance, it's a tax about the actual transfer rather than the agreement to transfer land.
Yes. Or as the way I put it was, has each party got substantially what they wanted out of the contract? Because once one or either party has got what they substantially want out of the contract, that's the moment at which the tax should be charged. Whether that consists in paying the large amount of money to the vendor or going into occupation of the whole, substantially the whole of possession of the property. And then shortly after that, in 2005, the tailpiece went on to bring in this exception in relating to 73.3. And I will come back to that and explain why it was that the legislature only had 73.3 in mind at the relevant time. Putting it quite simply, they're two entirely different sorts of transactions. 71A and 2 fall onto one side, and 73 actually turns the transaction on its head.
73 always is a sort of subsale.
It is. It's inevitably a subsale. But
stage 2 is a subsale under stage 1.
Indeed, but the person who's the subseller is a financial institution, and the person who takes the property is, of course, the counterparty.
Yeah.
Sooner or later, the question of exactly when one was going to, or the extent and application of Section 45.3 was tested in the Court of Appeal in DV3. And that was concerned with how the disregard in 45.3 should apply more generally for the purposes of the SDLT code. And that was what the Court of Appeal was particularly concerned about in DV3. DV3 is at page 1377. It's in the Second Authorities Bundle, tab 23.
You say 1377?
1377.
Thank you.
Now, I say 1377, but if you're using the electronic version, you may actually find yourself at you may need 1381.
Oh, okay.
Because at least there were 4 pages interpolated in my bundle at a later stage, around about 1180, which caused you to arrive a little early.
1377 is the first page of DV3.
Oh, then yours is working properly. Mine doesn't work quite so well.
We want the first page, do we?
What we're particularly concerned about, and what we can start with, is paragraph 11 of the judgment of Lord Justice Lewison, I think, at page 1382, where he explains what the case is concerned with. What the case was concerned with was a subsale into a partnership, and there were special rules in Part 3 of Schedule 15 to the Finance Act 2003, under which if a partner sold a property of which he was already the owner to a partnership of which he was the partner or a partner, then the legislature was concerned to mitigate the liability to tax that should be imposed on the partnership on the acquisition of the property interest, because it saw the partner as retaining a proportion of that equal to his partnership share. So if I sell property to a partnership consisting of A, B, and C, of which I am A and I own 1/3, then only 2/3 of the property should be brought into the charge of tax. And if, in fact, B and C were closely connected with me, those would be treated as acquisitions by me as well. And it was the policy of, as I say, the legislation, that you should only impose tax charge on that bit which was effectively not given away by the partner. And so the Court of Appeal had to consider a case of whether the legislature had intended that where the partner was acquiring the relevant interest as an intermediary in a subsale transaction, and immediately passing that interest on, having obtained the Section 45.3 disregard on the way through, should that relieving provision, paragraph 10 of Schedule 15, apply, given that there was no reality, as I say, to the interest of the partner, other than that very brief ownership that he'd acquired by reason of the contract with the original third-party vendor? Why, if there wasn't any such reality to the prior ownership, should relief be given from that particular acquisition, which was, when properly stood back and looked at and examined, to be seen as an acquisition from a third party by the partnership? Otherwise, it was a means of easily avoiding SDLT by buying and subselling into a partnership. And the relevant provision is at paragraph 11, and all one has to notice is there's the relief. It gives a rather complicated formula which basically looked at the market value of the interest, the property being acquired, and then deducting from it that proportion of the interest which was retained by the partner.
But it doesn't stop it being a land transaction. It just makes it one with a special chargeable consideration.
Oh, absolutely. I mean, and nothing here would prevent the final acquisition under a subsale from being a land transaction. In every case, you will have a land transaction.
Yeah.
It's because you've got a land transaction, you have a charge to tax. If you don't have a land transaction, you can't have a charge to tax. So the question is always going to be, is there a mitigation in the liability of the tax by a reduction in the amount of chargeable consideration, paragraph 10 of Schedule 15, or is there an exemption from tax by reason of the fact that this is seen as an appropriate acquisition from an appropriate person, as in Section 71A2? And we say that those two positions in DV3 and here are highly analogous. Each of them is looking at a very evanescent acquisition of a chargeable interest by an intermediary, of an interest in land by the intermediary, which doesn't amount to the acquisition of a chargeable interest. And each of them decides that it would be inappropriate in those circumstances to treat, in my submission, that as being a transaction which answers the purpose of the statutory provision which affords the relief in question. And the way in which Lord Justice Lewison and the rest of the Court of Appeal arrived at the conclusion in favour of the revenue in that case involved in a careful examination of the SDLT code. And in the context of that, Lord Justice Lewison saw Section 44 as being of central importance. That's paragraph 20 at page 1384. The upper tribunal had decided that, in fact, the way in which the Section 45.3 tailpiece operated was of a very limited meaning whatsoever and didn't operate outside Section 44. And because it didn't operate outside Section 44, you couldn't apply it to the rest of the code. No, said Lord Justice Lewison, you can, and one of those places where you can so apply it is, for example, in paragraph 10 of Schedule 15, because the real question is how Section 44 of the Act operates once you've made the relevant modifications required by Section 45. And since the Code as a whole was concerned with ensuring that a charge to tax was imposed on the occasion on which a chargeable interest was disposed of by one person and acquired by another, that is, disposed of by the vendor and acquired by a purchaser, and that was your land transaction for 42-43 purposes, one couldn't be a purchaser for STLT purposes unless the outcome of the relevant transaction was that one had acquired a chargeable interest. And neither could one be the vendor or transferor of a chargeable interest that one is deemed not yet to have acquired. One might have been the counterparty under the contract, passing or receiving the equitable interest. But that did not mean that what one passed or received was itself a chargeable interest. And that's what Lord Justice Lewison is saying at paragraph 23. The fact that B acquired a chargeable interest as a result of an instrument giving effect to a transaction between him and A does not necessarily entail the proposition the interest in A's hands was itself a chargeable interest. And the reason it was because the chargeable interest was still located in the hands of the original vendor, who was deemed never to have disposed of it until completion took place. And there one has the real-world analysis just below that, at the bottom of that paragraph. I see no inconsistency between, on the one hand, accepting the company was entitled to an equitable interest, which is an interest in land in the real world, and on the other, concluding the equitable interest does not count as a chargeable interest for the purposes of SDLT whilst in the hands of the company. And then you say, well, that doesn't mean that they have no part to play, and as my lady and your lordship saw this morning, there were various circumstances such as when completion takes place, which have to be discerned from the contract between B and C, but that doesn't mean that that contract guides the way in which the tax code operates in relation to the passing of the chargeable interest, or in deciding who is the purchaser or who is the vendor for SDLT purposes. And so in my submission, if a provision of the Finance Act prevents a person from acquiring a chargeable interest, that person cannot subsequently be treated as the vendor for SDLT purposes when that chargeable interest passes to a third party, even though he may be the seller under the contract by which the third party acquires the chargeable interest, or even the transferor of under the TR1. At least unless there is an operative deeming provision which requires a different conclusion to be drawn. And in my submission, there's no such provision here. And on the back of that, the court went on to consider how that would operate outside the scope of sections 44 and 45. And at page 1387, paragraphs 33 to 37, the judge discussed that. And essentially what he says in 33 is that section 44 dictates whether or not a person acquires a chargeable interest under a land transaction. And then paragraph 34, you then find section 42 preventing that happening again in relation to the entering into a contract. And then at 35, because the tailpiece to 45.3 is satisfied, the completion of the AB contract is disregarded for section 44 purposes, so there can be no land transaction under which B acquires a chargeable interest in accordance with 44.3. And so 44.2 and 45.3 taken together means that B never acquires a chargeable interest. And the outcome in paragraph 37 of the judge's judgment was that the company never acquired a chargeable interest of which it could dispose, and therefore, even though paragraph 10 was couched in terms of whether the partner was the transferor of the chargeable interest rather than the vendor, that was a distinction without a difference, because the company couldn't show that it was actually possessed of a chargeable interest which it could pass on. Now, it was unnecessary in DV3 for the court to answer the question if the partner didn't transfer the chargeable interest, who did, because there was no doubt that the partnership ended up with the chargeable interest. But had it asked that question, there is in my submission only one answer to which it could have given, which was that it was the original legal and general, in that particular case, Ministry of Defence here, who had been and was the person who had not disposed of the chargeable interest, even though they'd entered into a contract which was then completed by the subsale. So in a case like this, in my submission, if one is asked by section 71A2 whether or not the counterparty to the transaction is the vendor under the first transaction, the answer is no, it can't be, because the vendor is the person who transfers the chargeable interest, and it doesn't have a chargeable interest which it can transfer. Now, there is, of course, a provision which says otherwise, and that provision is section 45.5a. But it only does so where the context permits. And in my submission, when it says the context permits, it means when the statutory context permits. And the way my learned friend put it this morning was, you have to look to see whether there is anything which prevents PBL being treated as the vendor. And that's not the question the legislation asks. The legislation is asking whether or not, having regard to the context of the relief and the statutory relief that one is examining, is it appropriate in those circumstances to extend the statutory relief to circumstances in which the vendor is somebody such as PBL who had never really acquired the chargeable interest and who had not paid tax on its acquisition because they'd undertaken a transaction which fell squarely within section 45(3).
What, so the context which prevents it is that otherwise you end up with no tax at all, is that it?
Well, the context is slightly more sophisticated than that, but certainly that's basically it, yes. Do we really want this legislation, is this relief designed to enable taxpayers to avoid SDLT altogether on making subsales into ijaras? Or is the way in which Section 71A is drafted such that there is an expectation that someone will always have paid the tax, and if that tax has been paid by the counterparty, then there's no need for a further charge to tax. And if that tax hasn't been paid by the counterparty or anybody else, then the financial institution should pay the tax. Is the statutory purpose of the relief to enable one to get relief in circumstances where nobody else has paid the tax? In my submission, no.
Does that involve asking whether those who framed Section 71A had in mind this kind of ijara transaction?
Well, I confess I hesitate when asking whether draftsmen understand exactly what they're doing when they draft legislation, whether they've considered all the relevant context and cases. In my submission, what one asks, and perhaps what one is asking, is whether Parliament, in its wisdom when it was drafting this, intended this particular situation to be within the scope of the relief.
Right.
And in my submission, if Parliament had been asked whether or not this is one of the cases which falls within the scope of the relief, it would have said no. There is no need. And what is more, when one looks at the way in which the legislation is drafted, we say that you can discern that from Section 71A2 because the draftsman deliberately used the word vendor. Because at the time, as I said, when Section 72 was first introduced, and that was the first use of vendor, it bore its narrower meaning. It couldn't have a wider meaning. So if one was looking at what parliamentary draftsmen had in mind at that time, vendor only meant somebody within Section 43(4) who was a person who was disposing of a chargeable interest in land. Section 72 came into force. It was enacted on the 10th of July 2003. It came into force on the 1st of December 2003. 45(5)A was introduced with effect from the 18th of March 2004, and I'll explain why 45(5)A was introduced. And it was essentially to counteract an SDLT group avoidance scheme which had been spotted. And admittedly, 71A itself was not introduced as a separate entity from 72 until April 2005. But really, it's no more than a recasting in England and Wales and Scottish separate terms of the original legislation with the original concept of vendor still there. So when one is asking what the draftsman had in mind by the meaning of the word vendor at the relevant time, when the legislation was first introduced, it meant a person disposing of a chargeable interest in land and nothing more than that. Which then brings on...
Because of the absence of 5A, that's...
Because of the absence of 5A at that time. And if that is correct, one is then in the odd position that the argument of the revenue runs that, well, that was what vendor meant originally. By a side wind, 45(5)A extended and gave relief where it hadn't previously been available. They then say, well, that's okay because it was knocked on the head by 75A. But despite having been knocked on the head by 75A, the legislature then went on in the Finance Act 2011 to have another go at it as well by amending eventually 45.3 tailpiece to exclude 71A and 72 along with 73.
And the whole of 73, not just 73.3.
Yes.
Does that mean that if you looked at what was 5A in the same form after that came into force?
I don't think there were any further amendments to 45.5.
So if you look again at section 45.5A after the amendment in 2011 to section 45.3, the context would permit, would it, treating...
Well, at that stage...
Treating the intermediate party, the customer in this case, as the vendor.
Well, it would be the vendor.
Because there's no disregard.
Because there's no disregard.
Yeah.
So you don't need it after that because there is no disregard.
Yeah.
Yeah. I'm looking at...
Well, I mean, it's still there, so it still asks you to think which one is the appropriate one.
Well, of course, I mean,
so there'd be
because,
no
but
reason
you're
for
back to the
choosing
simple
anybody other
case.
than the vendor,
Yes.
other than,
Yes.
than the customer.
Yes.
Yeah.
Yes. I mean, it's then asking, is a financial institution buying in from a third party, or is it buying in from a person who's acquired a chargeable interest by reason of the disregard of 45.3?
Yes.
At that stage, you've got your chargeable interest. It's therefore capable of being passed on,
Yeah.
and therefore the intermediary...
And the bank is buying from a party that's going to have to pay the tax.
Yes.
Yeah.
Yeah.
Or they won't yet have paid the tax.
Yes. And of course, it was a deliberate decision in 71A and 72, and 73 as well, that the tax should be borne by the financial institution as a matter of policy. So it wasn't there was something wrong with banks paying tax. It was that a bank should only pay tax if it acquired a chargeable interest, provided always that nobody else had already paid the tax for it by acquiring that chargeable interest and paying the tax. And the Court of Appeal, in my respectful submission, does this very well. And I don't propose to take you to the Court of Appeal's decision, but I simply adopt it as part of my reasoning because it precisely sets out why it is that Section 71A should have the effect it does, why it's inappropriate to treat vendor as having a different meaning in 71A2 from the rest of the Act, and in particular Section 43.4. And why it's wholly inappropriate in circumstances like that MAR should have been entitled to relief under 71A2. I mean, an awful lot has been made by my learned friend about the use of different wording in 71A1 and how it talks about real-world property transactions. But what one has to bear in mind, in my respectful submission, is that one is trying to set the scene, create a narrative within which the operation of the rest of the section will work. You've got to be able to describe an Ijara transaction. You're inevitably going to describe your Ijara transactions as a combination of buying a freehold or long leasehold from somebody and then letting it to the counterparty together with options to buy and sell and so on. So it makes eminently good sense in 71A1 to have a narrative which sets the scene. But the rest of the section is designed to provide exemption from charges to tax. And if one asks, what is it that is charged to tax by the SDLT code? The answer is a land transaction. So that when one gets to section 71A2 and one is looking to see what it is that is being exempted, it has to be a land transaction under which the vendor is the counterparty.
I wonder, subsection 1, you say is real-world narrative, but thereafter it returns to the SDLT world.
Thereafter, one's dealing with construct, because what one is thereafter doing is looking transactions which are capable of being exempted for SDLT.
Yes, but yet, subsection 1 defines the first transaction, it defines the second transaction, it defines the further transaction, or it doesn't define the further transaction. The further transaction is defined in subsection 4, but they all refer back to the narrative arrangement rather than SDLT concepts.
That I agree, but of course it's only if what one can say in those circumstances it's only if the first transaction is itself a land transaction which requires to be exempted that you need the scope.
I see that point,
Yes, yes.
Because the assumption behind 2 is that but for the exemption, the first transaction would attract tax.
Yes.
Yes. And that applies because 2 therefore reflects back on 1A, and 3 in exactly the same way reflects back on 1B.
It does.
Sorry, 1C.
Yes, it reflects back on 1C. 3 is never going to be a problem because that transaction is always going to be a financial institution to counterparty transaction. So it doesn't need to be hedged around with questions as to whether or not somebody is the vendor or not. The only time when it's
That's true of 73.3 as well, isn't it, I think?
It is, exactly so. 73.3 doesn't actually ask whether or not the financial institution is the vendor, which is why the structure that was then counteracted by the interpolation of the exception or exclusion from the tailpiece was so important.
And focused on 3 rather than 2.
And focused on 3 rather than 2. Because the way in which it worked was that you had 2 transactions. First one was A to financial institution to counterparty. If you applied 73 by itself, A to financial institution was supposed to be covered by 73.2 and was only designed to give you relief in the event that A was actually the counterparty.
Yeah.
Financial institution to counterparty is 73.3. That works quite nicely, thank you very much. But what was suddenly realized was that if in fact you avoid having to rely on 73.2 by the A to financial institution transaction being disregarded under 45.3, you are then left with a disregard of the first half. You don't have to worry about 73.2 being engaged at all because the conditions just fall away.
Yeah.
And the
Provided
remaining
the vendor is.
Yes, and the remaining transaction is then, even if it's A to the counterparty, a third party to the counterparty, that is still exempted by 73.3 because 73.3 doesn't require that land transaction to be with anybody in particular.
Yeah.
It just says,
Well, no.
No.
For section 73 purposes, transaction 2 has to be bank to customer, doesn't
That's
it?
bank to customer.
oh, it will be to the customer. I mean, it's bound to be the customer. It's simply that it's a financial institution has been disregarded, and it's now a chargeable interest which passes from A to the customer.
Yeah.
As long as it's passing to the customer, it doesn't matter in 73.3 whether or not it passes from the financial institution, because that's not a condition of 73.3.
But in fact, the 2 transactions in 73.1a one would be a subsale to the other, wouldn't it? Because they are dealings in all or part of the same interest as is subject to the original.
Yes, it's going to be the same freehold passing.
So they had to disapply the disregard to make 73 work.
Yes, because otherwise 73.2 becomes useless.
Do you respond, would you respond in the same way as Mr. Gammy to my question about whether a sale by A to B followed by a lease back by B to A would be a subsale situation.
I have to, whether that would fall within 45.3.
Yes.
A sale and a lease on was always an extraordinarily difficult one to know whether or not it actually fell. I was always doubtful as to whether or not it fell within, or whether you could squeeze it within section 45.
Mr. Gammy says no.
No. To some extent, it may have been overtaken by events because paragraphs 12A and 12B of Schedule 17A to the Act deal with leases and subsales involving leases. But they're mainly to deal with cases where you have an agreement for a lease followed by the passing of the agreement to a third party. So it doesn't actually capture every case. So the revenue were always jealously guarded as to whether or not you were entitled to relief if you didn't actually get exactly the same chargeable interest or a slice of the same chargeable interest.
Well, the real question, I suppose, is an abstract question to whether a lease is a slice of a freehold.
Yes, or as a separate interest created.
Yes.
Certainly 43, I think, indicates that it operates in a slightly different way. Yeah. So if we then look at why 45.5a was introduced, my learned friend explained this quite well this morning. It was introduced because right at the start, SDLT was introduced in 2003 in order to put an end to all the tax avoidance industry which had grown up around stamp duty, where stamp duty was an entirely voluntary tax and one only paid a stamp duty if one wasn't well advised. Now,
Putting it a bit high.
there were circumstances in which perhaps tax was paid, but it was paid far less than one might have expected. And certainly for over 100 years, I think it was, there were all sorts of things that one could do which would have led to a significant mitigation and possibly even no tax at all, as long as you avoided the document or executed the document overseas. So there one was in 2003, enacting the legislation in July, implementing it in December, and by the time that December came round, the industry was already in full spate looking for ways of avoiding the tax again. And one of the things which immediately popped up into people's minds was, well, couldn't you actually do a subsale into a group structure? We don't know whether it works, but it could do, depending on who the vendor is. And before DV3 was decided, it was at least arguable that the parties to the transfer of rights were also the vendor and purchaser under the secondary contract. And if one looked at the first-tier tribunal decision in DV3, what they came up with as their secondary contract analysis was that there was, in fact, a tripartite contract between A, B, and C, which, if one took that view, one could see that one might then end up with a position that B was, in fact, a vendor as well as A. And that might then give substance to the sort of argument that was being touted by people in relation to group structure transactions. So that being the position, the revenue becoming alive to the possibility that this might happen, they took countervailing steps immediately to make sure that it didn't have any effect, which was the introduction of 45.5a, paragraph A. We don't know whether it works or not, but just in case you think it does, it doesn't, because we've now deemed the vendor to be the vendor under the original contract and nobody else. So 45.5a was introduced out of an abundance of caution. And 45.5ab was probably introduced in order to give...
Just to kick the can down the road.
Yes, exactly.
Here it ends up.
Yes, I'm afraid it did. But the answer is that perhaps inadequate thought was given to the drafting, and maybe it ought to say, where the context requires rather than the context permits. But in my submission, when one has a provision which says where the context permits and one's looking for statutory permission, one has to ask whether the statute permits, rather than whether the individuals have decided to choose one or other of the two possibilities as the vendor. And we now know that 45(a) was probably unnecessary, having regard to the decision of the Court of Appeal in DV3. At least 45(5AA), but like so much anti-avoidance legislation, it's introduced just in case something works that you don't think works, rather than because one introduces it because it necessarily does work. And that is what my Lord Hodge said in the Rangers case at paragraph 70, which is at page 1518 of the bundle. It's it's Authority Bundles 2, tab 28, page 1518.
Thank you very much.
And what was going on there was that when you're trying to interpret earlier tax legislation, it's always risky to rely on later counteraction of tax avoidance schemes, because it may well be that that legislation was introduced whether or not the scheme was actually effective. And it's therefore a weak life raft to which to cling in order to support an argument as to what the proper analysis of an earlier statutory provision is. Subsequent tax legislation, such as 45(5)(a), can't, designed to counter tax avoidance schemes, cannot affect the interpretation of earlier tax legislation. And so far as if the context here permits, in my respectful submission, the context cannot permit. For one reason, if one takes the position as it existed before 45(5)(a) was introduced, one was in a position that 71(a)(2) did not give relief in circumstances like this because vendor bore its meaning under 43(4).
Sorry, could you repeat that?
Yeah.
Your voice was dropping.
Prior to the introduction of 45(5)(a), when one had simply 43(4) as one's only definition of vendor, applying that rule, one ended up with the eminently sensible consequence that there wouldn't have been an exemption for MAR in circumstances like this buying in on a subsale, because it wouldn't have been buying from the counterparty, it would have been buying from the original vendor, as being the only person who had a chargeable interest to dispose of. The effect of 45(5)(a)(b) is therefore said to be to introduce a relief where a relief previously didn't exist. Because you're now saying that vendor can mean, for the purposes of this relief, PBL as well as MOD. And then one tests that by asking whether or not it could have possibly been the statutory purpose to have provided this additional relief in those circumstances where it hadn't previously existed. And whereas we know, rather than diminishing my argument resting on Rangers, at a later stage it was decided it was inappropriate for relief to be given in these circumstances. The thrust of the legislation is, as I say, to have one tax charge and make sure that tax charge sticks. And in circumstances like this, where previously the tax charge stuck, but has now been alleviated by the side wind of the introduction of 45(5)(a)(b), one has to ask whether or not the statutory context could really permit that to be the right answer. Is this a case where 45.5ab really ought to be applied to a section to give relief where otherwise it wouldn't have been available? There is, in my submission, no justification for giving relief in circumstances where the intermediary never has anything more than that evanescent interest to which I referred earlier, and where the result is to preclude any charge to tax where otherwise there would have been a perfectly reasonable single charge which would have been imposed on the financial institution. And in those circumstances, I submit there's no possible basis for the section's suggestion that the statutory context could permit. It's not a question of whether something, if there's anything that prevents, it's whether the statute ought to permit it.
That involves, does it, attributing to 71A by itself a purpose which fits with the what is obviously the overall purpose of having one lot of tax and not successive ones, but also not none.
Yes.
But another possibility, I suppose, is that 71A wouldn't do that at all if it had had from the very beginning what it has now, which is a hoiking out from the disregard of 45.3.
Oh, absolutely.
So that the error may as well be the failure to put it into 45.3 tailpiece as anything else. Or does that not work?
Well, one can explain historically why it was that things developed in the way they did, and the reason that in 2011 things developed in the way they did was that because DV3 had been going through the courts at that stage, and the DV3 analysis was entirely directed towards 45.3. Draftsman then says, or Parliament says, well, we've got to do something to knock this on the head. How do we knock it on the head? We have a choice. We can either do it by restricting the application of the tailpiece to 45.3, or we can do it by introducing a limitation in 71A and 72 and any other provision to which has the same effect. There is a choice, and Parliament simply adopted a choice, but it doesn't mean that having adopted that choice, again out of an abundance of caution, to knock something on the head which eventually DV3 and the Court of Appeal proved to be unnecessary. It was the only means of dealing with this at an earlier stage. So my submission is really very simple. There is no drafting error here. There was at all times a liability to tax on a financial institution acquiring a chargeable interest in circumstances such as these. There was nothing wrong with section 45.3. There was nothing wrong with section 71A2. The interpolation of the word vendor in 71A2 in fact does the job. And one can't therefore start relying on cases such as INCO in order to put right that which is not wrong, or to suggest that because there was another means which could have been used by Parliament to arrive at the result, and was used by Parliament out of an abundance of caution to arrive at the result which led to a different operation of the sections in the future, that meant that was necessarily the way those sections operated in the past.
73 was there from the beginning, was it?
73 was indeed there from the beginning.
It didn't get added into, sorry, the reference to it, I'm sorry, start again. It didn't get taken out of 45.3
No.
until
2005.
19th of May 2005, I think.
Yeah.
Yeah. So
You've got the little table at the very front.
It was an afterthought.
Yes, it was. It was. That having been said, I'm not sure I join my learned friend in saying that subsales into murabahas or subsales into ajaras are somehow an exception. think if one reads Mr. Latif's witness statement, paragraph 19 fairly, to which you were taken this morning, you'll just see that he's explaining what the plain vanilla sort of ijara is, and then says, well, there are these particular variations which have operated in this particular case. He's not saying that they're unusual. He's simply saying that if you had a very simple ijara, it would simply involve a purchase from a third party and a lease down to the counterparty with the options.
Yes, but it is of note, A, that in your written case in paragraph 14 and 15, you do not highlight this type of ijara, and B, that the parties proceeded in the documents which they submitted and for the first-tier tribunal on the basis that MAR was not the target of tax.
That is true. It's also true to say that at the time when this case was going through the first-tier tribunal, we were still struggling with DV3 and what the right answer was about section 45.3. And these two cases have overlapped to some extent in the courts, and inevitably, in the usual way of things, arguments develop as judges are providing us with answers on which we can rely.
But you've got, haven't you, in coming at this rather late, as some of us have, but I'm very conscious you haven't, but you've got in all these sections, 71A through to 73, and there are quite a lot of them now, they're all designed to deal with, to provide a fix, aren't they, to enable there to be the kind of Sharia-compliant form of financing, all of which involve what are ostensibly transfers of property.
Yes.
But they are transfers which are undertaken only for financing purposes rather than with a view to constituting new beneficial owners.
I am always really reluctant to take that analysis of an ijara or sharia transaction because it's so important to the parties.
That it does transfer.
It does.
All right, but it's a transfer for the purposes only of enabling somebody else to enjoy the property.
It does have that effect. But of course, as far as the bank is concerned, the bank's position is that it is important from a Sharia perspective to acquire a property interest which it can exploit by renting it out.
Yes.
Yes, I follow that. But you then have, as an afterthought, although quite a quick afterthought, in May 2005, I think it is, the extraction of one of those forms of Sharia financing from the disregard of 45.3, but for some reason or other not an extraction of the other one, 71A.
Which was already there, if I may say so, in the form of 72, but only in favour of individuals.
Yes. Yes.
Yeah.
In part, yes. But if one compares 71A and 73, taking two exemplars, one looks at the chain of transactions, they are the reverse of each other. 71A involves...
Well, they are, but they're both of them for chains of transactions in which there are interposed transfers which are designed for the purposes of financing.
Yes.
Once you the problem that this case shows up as surely is that once you couple that with the disregard in 45.3, you're in danger of ending up with no tax at all.
Well, in my respectful submission, one doesn't, but...
Yes, but there's clearly that risk.
Yes.
And it does strike me as very odd that 73 has been taken out of 45.3 and 71A hasn't until later. Is it not simply oversight?
In my submission, no.
Right.
It simply looks at the transactions that were undertaken, realizing that the effect of the disregard for 73 purposes was to remove the operation of 73.2, whereas the effect of the disregard in 45.3 as far as 71A was concerned was to leave 71A entirely alone and to operate in exactly the same way with the question of who is the vendor of that transaction.
But the disregard, the provision of 73, which was taken out of the disregard, wasn't 73.2, it was 73.3.
No, with respect, it
Wasn't it?
isn't. No, the way, if one, I do hope I haven't explained this already. If one looks at a third party to financial institution to counterparty transaction, which is what one is looking, sale by third party to financial institution followed by sale by financial institution to counterparty.
Yep.
The disregard is the sale by the from under 45.3 is the sale by the third party to the financial institution.
Yep.
That leaves the transaction between the financial institution and the counterparty in place. But that is now treated as a transfer, which under the secondary contract still leaves the counterparty as the purchaser of the chargeable interest, being the freehold which is passed. And it's that which is still exempted by 73.3. It's 73.2 which disappears and which is disapplied, has no application in a case where 45.3 applied in its original form.
All right. Yep.
And, I mean, it's not a possible other reason for doing it under 73 and not 71A or the old 72, that the two stages, the first and second transactions, are subsale related because they are disposal of the same interest, whereas in 71A bracket 72, they're arguably not because the second one is a leasehold.
Exactly so. Exactly so. That in my submission is certainly what made it obvious to the draftsman you needed to have
about
some.
whether a leasehold
Yes, yes, I can
can be
understand.
part of a subsale
Yes.
where the start-off process is a freehold.
Yes, but of
I
course,
think you're both saying is no.
yeah, I think we are both saying no.
I'm not quite sure I
But
can
we're
see
also
it.
saying that I think that in 71A, it's always going to be leased down by the financial institution to the counterparty, to the person.
Customer.
Whereas the first transaction is always going to be a purchase of what is more obviously a different chargeable interest in 71A2, being the freehold or long leasehold, whatever it was that one acquired, which itself was a major interest in land. And one can see that is a different structure and requires different handling. But if it had been something where Parliament was concerned about it at the time, one would have thought that having looked at 73 and seen that there was a problem with sub-sales into 73 transactions, the government would also, or HMRC would also have been saying, well, hang on a minute, we've got 3 of these sections here. Each of them is operating in a same sort of area. Shouldn't we be making sure that there isn't a sub-sale into a 71A problem as well? And in my submission, the likelihood is that it was explored at the time, and they said, no, we don't need that because vendor does the trick for us.
They weren't prepared to place their money on that because they then went and did 5A, 43 or 45.5A.
45.5A
You say was designed to deal with the risk that
Yes.
DV3 might turn out to be decided in the opposite way.
Well, 45.5A is obviously dealing with Schedule 7 and something that they were well aware of, absolutely. But I think I can at this stage pass on to the question of whether Section 71AC was actually satisfied in this case. Because my learned friend says, well, all that is terribly interesting, but even if you win on 71A, I'm still going to say that 75A is engaged in this occasion because there was no tax payable. 75A is at page 1079